This week on Legal Talk with Hahn and Hahn Attorneys, Thabiso Tshukudu joins us from the firm. He's a candidate attorney, and we'll be discussing suretyship today. We're going to ask him all about it and go into details. First of all, Thabiso, welcome to Legal Talk. Nice to chat to you for the first time.
Well, thank you for the invitation and the opportunity. I am excited to be here.
Excellent. Now, can you explain to us what is a surety or deed of suretyship?
Well, a surety is a person who undertakes to pay the debt or liability of another person in the event that the other person is unable to pay. Let me make an example. Let's say you are a director of a startup and you are desperate for finances for your startup, and you have assets in your personal capacity, and you decide, listen, I will take this 1 million rand loan and I will stand surety in my personal capacity in case the startup fails and I need to pay. So that's what a surety is. Someone who takes or who undertakes to pay the debt of someone else or another party if that other party fails to pay. And therefore, a deed of suretyship is the document that that person signs. What is important here is a deed of suretyship it cannot be a verbal agreement or an oral agreement. It has to be in writing, because when you get to court, for example, if you're suing someone, what the magistrate would want to see would be that particular document with that person's name and their signature thereon. So that in simple terms, that's what a surety is and a deed of suretyship is.
Okay, that makes sense. Now, let's say if someone has signed one of those, a deed or a suretyship for a principal debtor who cannot pay, do you now have to first sue the principal debtor before suing the surety, or how does it work?
Not necessarily. So if you find a smart lawyer to draft a deed of suretyship for you, what they will do is they will include a clause in the deed of suretyship. It's called waiving or renouncing the benefit of excursion. What it means is that once a person has signed a deed of suretyship that has that clause basically means that that person waives the right for you to go after the principal debtor first. You can go after both of them at the same time, or you can go after the deed of suretyship, or you can go after the principal debtor. So in other words, once that clause is there, it means you are not precluded from going after this one surety by themselves. But if that if there is a clause that says, listen, you cannot go after me, you must go after the principal debtor, then you would have to go after the principal debtor. But a wise agreement would include the renunciation of the benefit of excursion, which means that you can go after both of them or go after the suretyship, or rather the surety.
Okay, and what is the effective and efficient way to sue against a surety?
So what is amazing about an acknowledgement of debt and a deed of suretyship is that when you have that kind of a document in place and someone defaults on their payment, and you have this deed, the surety to go after, is that you don't have to go the long route of granting summons, waiting for a notice of intention to defend, then a plea, then you respond to their plea, and so forth. You can issue what we call provisional sentence summons, which is the most efficient and effective way to go after a surety and get your money. What the provisional sentence summons basically do is a lawyer would have to draft them, attach that deed of surety, and put facts before a court that shows that you actually owe the money and you signed this deed of suretyship. What would happen is the court will invite the suretyship on a particular day to come and do two things. Number one, they would come to either admit or deny liability. Secondly, they would have to confirm the signature on the deed of suretyship and probably give a defense. and a court will have to decide whether the defense is valid or not. And if they find that the defense is not valid, then they would grant a provisional judgment there and then. So what that does is you don't have to go through that whole process and this back and forth and stuff like that. You just simply go through this very short process where you can get the relief that you actually seek.
And then finally, what advice do you have for someone who is about to sign a surety?
Well, the advice that I have for a person who is about to sign a deed of surety is that you need to know what you are getting yourself into. It cannot be an emotion-driven experience, because the consequences and the repercussions could be devastating.
Yeah.
It's just simply because you just want this relief that you seek at that particular moment. So you really need to know and in fact negotiate probably some of the terms if there is a need for them to be actually varied, instead of simply just accepting it as it is. You can negotiate, for example, the benefit of excursion, so that you go after the principal debtor before you come after me. And for a company, for example, that is in business and makes people to sign deeds of suretyship, is in fact to look at the clauses that they have, to make sure that they've got the right clauses in place in order to go after the suretyship, or to in fact get fast and swift relief in a case where people default.
And that was Thabiso Tshukudu from Hahn & Hahn Attorneys. Thank you so much for your advice and time today.
Thank you for the opportunity.
Are you or your business in trouble and struggling to find a solution? Call Hahn & Hahn Attorneys, as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations, and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn & Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn & Hahn Attorneys, Wednesday mornings at 10 on eRadio.